It could set an unfortunate precedent that legislation that retroactively deprives one's constitutional rights could be upheld as constitutional.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
About 10 days ago, we filed an amicus brief with the United States Supreme Court on FAPA. Last week, we broke down the amicus process. And this week, we're going to be changing the focus a little bit while staying on the same topic. And we'll be meeting with Friedman Vartolo partner Zach Gold to go over what the real-world impact of this amicus brief could be, what arguments we made in our brief, and so on. Thanks for joining me, Zach.
Good to be here, Adam.
Look, congrats on the amicus filing.
Thank you.
Very big news for our industry, something our firm is very proud of. So congratulations on that.
Thank you so much.
These things get complicated. So we filed an amicus brief on a case. What are the facts of that case?
It all started back in 2010 with a foreclosure action that was commenced against a defendant. Several years later, that action ultimately got dismissed, and I believe it was 2021. The dismissal was affirmed by the appellate division. A second foreclosure action was commenced in reliance on what is called the New York Saving Statute, which allows you to recommence an action within 6 months of dismissal of a prior action. So U.S. Bank, the plaintiff and the petitioner on the brief, ends up recommencing an action in 2021. And initially that action gets dismissed, but then the appellate division reverses that dismissal and they find that the action was timely commenced in reliance on this New York Saving Statute. What happens in the interim is that FAPA, the Foreclosure Abuse Prevention Act, gets passed, and the defendant, Fox, then brings a motion to re-argue at the appellate division level. And the appellate division agrees with his argument that FAPA should apply to this action retroactively, and that the new CPLR 205, which is now called CPLR 205-A, should apply, and that this action is untimely, and they grant re-argument and dismiss the foreclosure. So they declare it untimely. U.S. Bank then petitions the Court of Appeals to hear the issue, and they decline to grant that petition. And that's where we get involved. Then the groups got together and decided this is a good opportunity to challenge FAPA, perhaps at the federal level, and seek leave or petition the Supreme Court of the United States to determine the constitutionality of FAPA.
I want to highlight why this fact pattern feels perfect for a FAPA challenge at this level. The decision in 2021 that reverses the dismissal on the basis of the saving statute, FAPA is then the next year. And FAPA gets rid of the saving statute and also imposes it retroactively, right? Mm-hmm. So the fact that this dismissal was vacated in 2021 or overturned in 2021, and then 2022 FAPA comes around, the defendant decides to renew and re-argue X amount of time post-FAPA, and then reversing it again, it's a perfect fact pattern. But how did we get all the way to the U.S. Supreme Court?
So they haven't officially taken the case. We're seeking permission for them to take the case. But the reason we think that they should take the case is because it's a clear factual record. It's a final determination. It is, we argue, a case of national importance, and it implicates important constitutional rights like property rights, i.e., the mortgage. And also, I think, because there is a strong divide in the various jurisdictions. So we have federal courts chiming in and the Second Circuit saying effectively, we think there are issues here of federal constitutional importance that need to be addressed. So I think the balance of those factors make it ripe for SCOTUS review.
When you say that some of these issues are of national importance, are you speaking specifically to due process concerns and the loss of the mortgages, or are you saying FAPA itself, the fact that there's a retroactivity? What exactly are you saying is the national concern?
Yeah, I think it's both, to answer your question. So property rights and the protections afforded by the Constitution are, of course, of national importance. But also, we have a New York State legislature passing this law, but if other states follow suit, this then becomes something that is of national significance.
Within our amicus brief, what are our arguments?
I think it's important to understand the landscape that precipitated this brief. So we had appellate division decisions, several of them, finding that not only was FAPA to be applied retroactively, but also that that application was constitutional. So in our preparation of the brief, we of course wanted to address those arguments, but the petitioner, the actual plaintiff in the foreclosure, they were going to touch upon all those issues. So the due process arguments, the takings clause arguments. We wanted to really focus our brief on behalf of the parties that we were authoring the brief on. So that is the different trade organizations. So our focus was, how are these stakeholders hurt by this legislation? And of course, the parties that they represent. Mm-hmm. So our brief focused on the market impacts of this legislation, how this was going to affect mortgage lending in general, the harms that were caused by the legislation to the industry at large. Of course, we did address what we believe to be a clear due process violation and a takings clause violation. I'll just briefly touch upon those. So our taking clause argument is essentially what I indicated before. So a mortgage is a property right protected the same way that you have a property right in your home. Causes of action can also be deemed property rights. So FAPA was a law that was passed and retroactively took away these property rights from the stakeholders. So our argument was that this was a violation, that this deprivation of our right to foreclose on that mortgage and the cause of action to foreclose on a mortgage was a constitutional violation. The due process one is similarly related. So the retroactive application of FAPA to past conduct, to past action, to actions that were pending, that was a violation of due process. The absurdity of taking law and applying it to past conduct, because we, as lawyers and our clients, we act on the law as it exists. And so that was really the nature of our due process argument. So those were our two big constitutional points, and they mirrored points that I'm sure the petitioner made or will make in support of their brief as well. The first A in FAPA is abuse. And one of the things that the statute was supposed to prevent was purported abuses by the plaintiffs. And we discussed how, in reality, it results in abuse. And we really highlighted the current legal landscape in New York as it pertains to foreclosures and how it's really become a complete gauntlet, and that this is sort of the straw that could potentially break the camel's back. We really got into a lot of statistics and details. For instance, the average foreclosure in New York takes almost 6 years to complete, but the statute of limitations in New York is only 6 years. So there's a disconnect there. We also delved into some of these landmines in New York, like being stuck in settlement conferences for 2 years, or being faced with the decision whether to appeal any interlocutory decision and the resulting 2-year delay that one could face if you elect to appeal a decision from the lower court. So we really wanted to paint a picture for the Supreme Court, the realities on the ground in New York, what we're dealing with, and how this legislation doesn't prevent abuse, but just really makes it impossible to foreclose. We also wanted to impress upon the court that any foreclosure in New York is in jeopardy as a result of this legislation. Because if foreclosures are taking 6 years, any minor misstep, you are at risk. So we wanted to impress upon the court how this is not a small number of cases, but could result in an egregious harm, but also something of national importance that they should address.
So what's the best case scenario and what's the worst case scenario?
I think the best case scenario is they grant certiorari and they hear the arguments and determine that retroactive application of FAPA is unconstitutional. That would be the best case scenario. Conversely, the worst case scenario would be, it wouldn't be the end of the world if they didn't grant the petition. But if they did and then they held that it was constitutional to retroactively apply FAPA, that would obviously be a major blow. It could not just impact FAPA, but it could set an unfortunate precedent that legislation that retroactively deprives one's constitutional rights could be upheld as constitutional. You're supposed to be able to govern your conduct based on the law as it exists.
Thanks for joining Friedman Vartolo partner Zach Gold and I on the Weekly Friedman, your source of the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.